Hello students, welcome back to SuperKalam in this very special initiative on NCERTs. I am Madhur, your mentor. With the experience of giving two civil services interviews, I am back with the second lecture on Indian polity, class 11th NCERT called Indian Constitution at Work. Before that, I just want to tell for the new students who are starting today that this initiative, Super Start with NCRTs, is focused on strengthening your foundation, strengthening your conceptual understanding. In this initiative, we will cover a lot of different NCRTs. I'll cover polity, other teachers will cover science and technology, history, then we will later also come with geography, etc. So that the very foundation which NCRTs provide for civil service preparation is strengthened for you all, right? So this is all about the initiative. Now let's start with the second lecture, which is on rights. So this is basically the chapter 2 of our class 11th NCRT, which says rights in the Indian Constitution. So this is a very crucial, important topic, which will delve into fundamental rights, and also little bit into directive principles of state policy. So these are the two basic focus point of today's class. Now let's start with the first section, fundamental rights. Now before that, your NCRT starts with a very nice illustration, very nice, very serious illustration, which I'll tell you. So NCRT talk about Asian Games. So Asian Games were held in India in 1982. There was preparation going on. The contractors basically hired lot of workers, lot of construction workers, and those construction workers were given very less wages. Their condition was also very poor. They were not given good houses, etc. So they were exploited in a way. So then the case went into Supreme Court. What does the Supreme Court said? Supreme Court said that denying this basic minimum wage amounts to bonded labor, and therefore the contractor should protect the fundamental right of the workers. They should give proper wages. So giving proper wages is, as per Supreme Court, the fundamental right of workers. Now which fundamental right it is exactly the part of I'll cover in this class in the later section. Now with this story you must have understood that rights of workers in this case, or rights in general, are very important for a dignified life. That's the basic definition of fundamental rights, or rather, that's the basic definition of rights in itself. As I have written from NCERT, rights are guarantees of conditions essential for individuals to live life with dignity. So, dignified life is the basic essence of rights. And rights also place certain obligations, certain duty on the state, so that state act in just and fair manner. For instance, the state should ensure that the poor, women, Dalits, whose rights are violated, who are discriminated in our society, should be protected. It's a duty of the state. So that's why rights first ensure dignified life for every individual, and uh, also makes government responsible that they act in a fair manner. They do not discriminate against individuals. They do not act in an arbitrary manner. So that's the basic essence of rights. Now, rights are of many types, but our book basically try to distinguish between two concepts of rights, which is fundamental rights and legal rights. Now, there is a very small difference. Although they both are rights, but there is a very small difference. Let's delve into it. Now, fundamental rights, very fundamental, very foundational, and these are guaranteed. Guaranteed means there's a guarantee that you will get them. They are guaranteed by the Constitution in Part 3. But legal rights are made by ordinary legislations. For example, Parliament will make any act, and that act can give you a right. I'll give you example for this, don't worry. Fundamental rights are enforceable by courts, means if part 3 rights are exploited, you can directly go to court. You can go to Supreme Court or High Court and say to them that my rights are violated and court will act. So that's why they are enforceable. That's the meaning of enforceable. But legal rights can be enforceable by courts or can be enforceable by any other body or may not be enforceable also. There can be very much distinction about it. Now, there is one right which is right to property. Now, right to property is not a fundamental right. Earlier, it used to be a fundamental right, but it is not now. Why? Because it has been removed from Part 3. I want to know from you all that which amendment removed right to property from fundamental rights. Just tell me in the comments, right? But right to property is now a legal right. It is moved to other part of the constitution. So this is the basic, very, very crucial, very important right which comes under legal right but not under fundamental right. So this is one aspect of it. This is the difference between fundamental and legal rights. Now, rights can also be expanded or removed. As I told you, right to property was removed from fundamental rights, and rights can be expanded also. There is Article 21A, which was not there in original constitution, but the government amended Part 3 and added this article. So this is how it expanded, and this is how it removed. Through amendments, the parliament can remove or add to this fundamental rights, to this Part 3. Clear? Now we will move further. Now we will come. We will start with fundamental rights. So we have understood about rights. We have understood the difference between fundamental rights and legal rights. Now, what is the structure of fundamental rights? As I said, fundamental rights are very fundamental in nature, and these are enforced by judiciary. And these are very well defined in Part 3 of the Constitution. Also, they are very systematically organized into our Constitution. Now, these are all rights which I have written, but I want to show you through this page from the chapter itself. See this Constitution of India, Part 3. It tells about all these rights, which I'll discuss in detail with you now. So this page you can refer to for summary. You can even take a printout and you can stick on your near your desks. Okay. Now, so these rights are the 6 categories. Right to equality. Equality means uh, uh, is making citizens equal, treating them in an equal fashion. Right to freedom, ensuring that everyone is free to do his or her affairs, to organize, to live in a free manner. Right against exploitation, to ensure that their citizens are not exploited. Right to freedom of religion, the freedom to practice religion. Cultural and education rights, to protect your culture and to ensure that you are educated. And right to constitutional remedies means you have a right to remedy. That means if your rights are violated, you have a remedy to it. Now, these are very comprehensive in nature, these rights. So, therefore, I take these one by one in next few slides. So, first one is right to equality. Now, right to equality is covered under Article 14, 15, 16, 17, and 18. Now, what does Article 14 says? Article 14 says that there will be equality before law. That means everyone is equal in the eye of law, whether it is a rich man or a poor person. They both are equal. For a similar crime, they both will be treated similarly. That's the meaning of equality before law. No one is, there's no exceptions. No one is above law. Everyone will be treated in an equitable manner. There are few exceptions, although, for example, the President of India and the governor. In few cases, for example, no criminal case can be started against them while they are in office. That's a basic exception given to in this right. Otherwise, no discrimination can be made. Second is Article 15, which says that there will be no discrimination. Neither state nor any individual can discriminate between any individual on the basis of race, religion, caste, sex, and place of birth. So on these basis, no one, even state or individual, can discriminate. If someone is Hindu, someone is Muslim, no discrimination. If someone is from South, someone is black, someone is white, someone is from Dalit category, someone is from so-called upper category, no discrimination will be there. So that's the meaning of Article 15. There was a movie also on Article 15. You can watch that. Next is Article 16, equal opportunity in public employment. That means everyone is equally available, equally qualified. There will be not equally qualified, but they can go for public employment with an equal opportunity. There will be no discrimination. That is Article 16. Article 17 is abolition of untouchability. Now, what does that mean? So there was untouchability earlier in our society. Even to some extent, it is there today also, although it has been reduced. Untouchability means that people from a particular caste, they will not touch. They will even not come under the shadow of a Dalit or a untouchable or a person from lower caste. That was the untouchability. That was a tradition of untouchability, which was very bad, which used to undermine the dignity of an individual. So that was abolished by Article 17. Article 18 is abolition of titles. So earlier during the British Raj, there used to be titles like Raj Bahadur, etc. So these titles created some sort of distinction, discrimination between individuals. Therefore, these were also abolished. Now, there are some awards which are given by India, for example, Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. So these are not categorized as titles, but the court and the government has mandated that no awardee of these awards can use these titles before their name. So that is one more, development which comes under Article 18 only, which you should remember. Okay. Now we will move into a second aspect, which is right to freedom. Right to freedom is covered in Article 19 to 22. Now, this is very important, and I want you to put your attention here. I will cover this in detail. Article 19 talks about 6 freedoms which every individual will get. What are these? Freedom of speech and expression. I can speak, I can express myself in a free manner. I am not living in a dictatorship. I am living in a democracy. This is the very essence of democracy. All your rights, like right to information, etc., your right to protest, right to write freely in newspaper, they all come from this right to speech and expression. Right. Next is right to movement, means you can move freely in any part of the country. Then there is right to assembly. You can assemble at any place, but without arms. Right to association. You can form various associations, groups, cooperatives, organizations, etc. Right to residence. You can reside freely in any part of the country. And right to profession. You can do any profession freely. You have a right to do that. But there is a catch here. If I will have a right to speech, then I can abuse someone. Now, if I abuse someone, that person, the dignity of that person will be lost, his right will be lost. So that's why there are some reasonable restrictions on each of these rights. I'll take one example. There's a reasonable restriction to speech. I have a right to speech, but I have to take care. I have to mind that my speech should not undermine the sovereignty and integrity of India. My speech should not incite any offense, that I am giving some hate speech and it is inciting an offense. No, I cannot do that because those are restrictions on my speech. I cannot defame anyone. I cannot contempt the court. I cannot abuse or basically put hurdles in the working of the court. So these are few restrictions which I have on my speech. Now these are not very directly given in NCERT, but these are given in Lakshmikant and they are important also. So I want you all to also refer parallelly to Lakshmikant because they are not directly given in NCERTs. In the same way, I have a right to movement, but there are few tribal areas. There are very much few areas in northeast which have a permit system. Why? To protect the tribal culture. If I'll go freely there, I'll settle freely there. Their culture, their values, their they can be exploited. That's why there is some limitation in right to movement also. There's a limitation on profession of certain professions. Why? Because if I have a right of profession, I may do any illegal profession, but it shouldn't be done so. That's why this is the restriction on profession as well. So if I summarize this, these are very important rights which are important for a democratic country, like to speech, movement, assembly, association. But there are some reasonable restrictions. There are some restrictions. Why? Because I cannot undermine others' rights. That's why there are these restrictions. So this article becomes very, very important part of the constitution. You should read this article in detail, right? Then let's move to next article, which comes under right to freedom only, which is protection in conviction of offense. There are three parts to it. One part is that you cannot be convicted for the same offense twice, right? Second is you cannot be asked to give evidence or give any kind of uh, opinions against you if you are convicted. For example, if I am convicted in any offense, then I have a right to remain silent. I have a right that I'll not tell anything against myself, that I have a right. And third is that I will be convicted according to those laws which are live, which are currently applicable when that crime was done. I cannot be convicted as per any law which was which will be applicable in future. For example, if I committed some crime today, then whatever laws will say today with respect to that crime, I will be convicted according to that crime. So these are three very much important protections in conviction of offenses. One was I cannot be convicted for same offense twice. Second, I can be convicted only with in context with the laws which are applicable at that time. And third, I cannot be forced to give any evidence, any observation against myself if I am convicted. Right. So this is Article 20. It protects, so it basically puts a restriction on the government that government cannot unnecessarily force anyone to go to jail. Government cannot unnecessarily force anyone to be convicted in an offense. That's why this article becomes important. That it is also very much a sense of democracy and also a check on the government. This is now Article 21. Very beautiful article, very diverse article. It has been expanded like anything. Now, I want to cover this in detail. Article 21 says that there will be life and liberty. That means freedom to live and freedom to dignity and freedom to live in a free manner. Now earlier there was a very literal meaning to it. Right to life means no one can kill me, and right to liberty means that I will do things as per my. But this was very narrow understanding of this article. Therefore, Supreme Court has time and again, even till now, Supreme Court keeps on expanding the nature of this article. In the first class, I told about how judiciary expands the meaning of terms, meanings of various constitutional provisions. So judiciary has expanded the meaning of Article 21. Now Article 21 even covers right to clean air. In the recent cases only, there was a case called MC Mehta case. There was a case, if I am remembering correctly, Ranjit Singh case. So in these cases, Supreme Court said that there is a right to clean environment. Then there is a right to shelter. Under this article, there is a right to sound sleep also. Because without sleep, how can you live your life with dignity? In the same way, right to dignity has been explicitly made part of this right to dignity. It was asked in previous year question also. I'll cover at the end. It has also been the part of Article 21. So I want to just say that this article keeps on changing, keeps on not changing, keeps on expanding. The meaning keeps on expanding, and therefore it becomes a very potential question of prelims as well as mains. It has been asked multiple times. You should look at the PYQs for the same. Then Article 22, protection from arbitrary arrest and detention. The government cannot arbitrarily arrest you. If the government is arresting you, you have certain rights. For example, you have to be produced before the judge within 24 hours. You have to be communicated the reason of your arrests. You have to be given the lawyer support. These are the rights in order to avoid arbitrary arrest. So therefore, if I summarize this article becomes the soul of liberty. In the first class, I talked about liberty, which we have borrowed from article from French Constitution. These articles basically they epitomize liberty. They tell us how that liberty has to be enforced. I have a liberty to express myself, to freely move. And the government cannot put me in jail in an arbitrary fashion. I have a liberty, I have a right to live a dignified life. That's why this becomes very important. Not only from the perspective of you being you being preparing for civil services, but as a responsible citizen also, you should be aware about these articles. Okay. Now we will move further in right against exploitation. Now, if you remember in the starting of the class, I told you the story of Asian Games. Now, that particular violation of rights, the violation of right by contractor by giving less wages to the workers, that violation comes under Article 23, which prohibits forced labor and begar. Begar was used to happen earlier in British India. It was a type of bonded labor. So, in that Asian Games case, which I was referring to, the Supreme Court said that giving less wages is like forced labor. You are supporting forced labor. So that's why Supreme Court protected the rights of the workers at that time. That's the essence of Article 23, which says that nobody can be forced. Nobody can be forced to do a forced labor or to work at a lower salary. This all comes under Article 23. But there is a restriction here. The restriction is here that in an emergency situation, the government can mandate some compulsory services. This has not happened up till now, but its meaning I will try to explain. So, if for suppose there is unfortunate war and there is a deficiency of maybe army personnel, or there is, for example, there is a disaster in an area, and we know a lot of people from the locals. So in that case, the government can mandate the service that you have to come, you have to join army, you have to come, you have to support the disaster management process. In that way, the government can mandate it. So that will not be counted as a forced labor. But the government has to ensure that in such cases, it is not distinguishing in terms of caste, in terms of religion, in terms of languages. If government is doing any emergency measures, so the government has to ensure this. Now the next is Article 24, which prohibits child labor. This also comes under exploitation, right against exploitation. Now explicitly in this Article 24, it is mentioned that children less than 14 years of age cannot be employed in hazardous factories. Why? Because see, it's a very uh, tender age for children. and children are also very delicate. So therefore, to ensure that there is a development, there is a holistic development of children, and they are giving good environment, this right becomes important. Earlier, child used to be a norm. Even today, there are instances of child labor happening. That's why this becomes important. And government has also brought a law under it, which has further enhanced the meaning. Now, the Constitution only says that for less than 40 years cannot be employed in hazardous industries, but the government has created further segregation. The government in the law has strengthened this. Government has said that below 14 years, children cannot be employed in any industry except some kind of entertainment industries and also some home-based industries. Except that, they cannot be employed. The government has further enhanced the meaning, the essence of this article. So this was all about right against exploitation. Now the next is right to freedom of religion. Very widely debated, always, almost always in news. So that's why it becomes very important to you from a civic perspective also to understand this article. Right to freedom of religion has four articles under it. First one is important one, Article 25. What does it say? It says there be freedom of conscience. What does that mean? Freedom means I, through my inner feeling, can decide which religion I have to follow and what way I have to follow. No one can force me. I have that freedom. That is a conscience, freedom of conscience. And the other part is right to profess, freedom to profess, practice, and propagate any religion. Now, these are very important words which whose meaning you should understand. Profess means to tell that, oh, I belong to this particular religion. I can freely profess it. There is no restrictions on my profession. I can freely tell to everyone. Right to practice. So this is a basically a ritualistic angle. I can do rituals. Whatever rituals are part of my religion, I can do them freely. That I have a right to do them. And third is right to propagate. I can tell people, I can motivate people to join my religion, but I cannot force them. Supreme Court, as in its ruling, have said that forced conversion is not a part of propagation. Is not a part of propagation. So conscience is so I'll again say conscience is inner feeling, what I feel about a particular religion which I am following. Profess is telling people that I belong to this religion, proudly telling them. Practices to do rituals pertaining to that religion, and propagate means to spread the learnings, the teachings of my religion. This is the meaning of Article 25. But there are reasonable restrictions here as well. Practicing religion does not mean that you block roads, you compromise the health of the people. So therefore there are restrictions. You cannot compromise public order, you cannot compromise morality and health. That you have to ensure while practicing, professing, and propagating a religion. Right, so this becomes very important. Now this also becomes important from secularism perspective. India is a secular country, our preamble says that, and we all have freedom to profess our religion. That's why this becomes very important from secularism angle also. So whenever you get any question of secularism, you should mention this article from Constitution. Second is Article 26, right to manage religious affairs. So religious bodies can basically establish temples. They can manage that temple, and government has no right to interfere in its functioning. That's the meaning of Article 26. Now, all the Waqf controversy which came in, basically this article is very much linked to that controversy which is going on in news regarding Waqf. The law has been passed, but it has gone to Supreme Court. So the court will basically interpret what is the meaning of this article and how it is applicable to Waqf. We have to wait for the ruling. Article 27, it says that government cannot tax you for propagating a particular religion. Prohibition of taxation for religious purpose. Now, government has to propagate, has to support all religion. It cannot do bias. That is the meaning of this article. And second, for religious purpose, government cannot tax you. Although there can be some fee, For example, if you are going some temple or some religious institution, there can be fee. Fees is very different, but taxation is very different. Article 28 says that no religious instructions in state funded institutions. That means if government is funding any institution, government cannot propagate any particular religious teachings in that school. Why? Because government has to be neutral. Government has to propagate all religion, which Article 27 says. That's why government cannot say that a particular religious instruction should be given in the institute. Right? This is basically this. These four articles are the essence of secularism. Secularism in India means that so it has multiple aspects to it. First, it means that there is a freedom to individual to practice religion. Second is government will support all religion, and their third is that you are free to do ritual activities. So this is basically the essence of Indian secularism. Now, secularism itself is a very broad context for concept. We will cover some other time, but in India, it is the essence of Article 25 to 28. Right. So now there is this small section on cultural and education rights. Article 29 and 30 talks about it. Now, Article 29 says that everyone has a right to protect interest of minorities to preserve culture. Now, although it's written minorities here, but everyone has a right to preserve their culture. Now, what does it cover? It covers language, it covers script, it covers culture. So, minorities as well as non-minorities have a right to preserve their language, script, culture. In constitution it was written minorities, but if you read the article very carefully, it is written any persons have a right to preserve that culture. That's why its meaning is broad, and Supreme Court also has upheld it. So this is Article 29, according to which everyone has a right to protect their language, script, and culture. Then there is Article 30, which says, now this is applicable for minorities only, which says that minorities have a right to establish and administer educational institutions. So this is given to minority institutions only. Now there are a lot of madrasas, which to some extent falls under this. They have a right to establish and administer education institutions. Therefore, there was a controversy with respect to Aligarh Muslim University. Now the case has been closed. Aligarh Muslim University has been given a tag of minority status. Now, because it has been given a tag of minority status, therefore the administrators who administer this university will have a right to determine what type of people they will invite, how teachers will be selected, how students will be selected. So there is a certain autonomy to these institutions, these minority education institutions. Right. Now, all this done, but there is a basic question which arises. These rights are given in constitution. Now, if there is no right to remedy the violation of these rights, then these will be null and void. That's why our constitution very smartly it gives one more right to fulfill all other rights. It is right to constitutional remedies. Basically, constitutional remedies means if any of your rights, which I mentioned in previous pages, is violated, you can get a remedy of it. You can go to directly to Supreme Court as under Article 32, and Supreme Court is bound to enforce your right. How it does, I'll tell in a while, but this is the essence. That's why even Dr. B.R. Ambedkar called this as the heart and soul of the Constitution. Why? Because without the right to constitutional remedies, there will be no enforceability. The government can take the earlier rights for granted. There will be no enforceability. That's why this right enforces all other rights. And judiciary has a very important role here. Now, there are multiple ways in which judiciary protect the right through PILs. Like, for example, this Asian Games case, In this case, a PIL could have been filed, public interest litigation. PIL is a very uh, special type of, you can say, legal system, legal document, which the court takes cognizance of, and courts can give a ruling. Then Supreme Court through judicial interpretation, as I told you in last slide, Supreme Court has protected the rights by expanding the meaning of rights. That is a role played by judiciary. And there is one more way through which judiciary protects the rights, which is by issuing writs. Writs are like orders. The Supreme Court can issue that orders. Supreme Court has the right to issue that order. Now I'll cover these writs in some detail with you. So there are five writs which court, both High Court and Supreme Court, can issue. First is writ of habeas corpus. Habeas corpus means to have a body of. So Supreme Court can say, so anyone who is detained illegally, I told you in the earlier slide, detaining illegally, Article 20 and 22. So Supreme Court, so that person or person's family can go to Supreme Court, and Supreme Court can order that I want to have the body, I want to have that person in front of me. So what will be the impact of this? Now, when that person will come in front of Supreme Court, that person can claim that my rights have been violated. I have been captured illegally. So that's why this ensures bodily autonomy, the writ of habeas corpus. Then there's a writ of mandamus, which is issued by judiciary. Mandamus means we command. Under this, judiciary, Supreme Court precisely under Article 32, can command any officer, any official, that why are you not doing this particular duty which is assigned to you? You have to do this duty. We are commanding that you do this duty. That is writ of mandamus. Then there is writ of prohibition. Now, this writ of prohibition is issued to lower judiciary by Supreme Court. Under this writ, the Supreme Court says that you should prohibit, you should not act in a particular case. Why? Because you are overreaching your jurisdiction. So Supreme Court ensures that lower courts are not overreaching their jurisdiction by issuing writ of prohibition. Writ of certiorari. Now it ensures that the higher court or Supreme Court precisely says to Supreme Court to lower courts that you prohibit in a particular order and transfer those orders to me. In prohibition, the court is only prohibiting lower judiciary, but in certiorari, the court is prohibiting also, and it is taking the case itself so that justice is done. Then next is quo warranto. Quo warranto means with what authority? With what authority? So if any official or any person with illegal of authority or in an illegal way assumes any office, then Supreme Court can issue this writ of quo warranto and can ask with what authority are you holding that office? You should remove yourself from that office. That is basically the quo warranto. So these writs basically ensure that Supreme Court, with a very powerful manner, asks the government uh, and ensures that if any violation of fundamental rights are happening, government is made accountable, and government, releases the citizens from that violation. That is right to constitutional remedies. It is very important right. Without this right, the other rights would have been only in letter, not in spirit. That's why this becomes very important right. Now, this right section is complete. I'll briefly, so in NCERT, directive principles of state policy are not covered in very detail. So I'll not cover in very detail here. I'll very briefly tell you the difference between fundamental rights and directive principles. Directive principles, which are are in part 4 of the Constitution. They both together are called conscience of Indian Constitution. Conscience, essence, soul of Indian Constitution. Fundamental rights have lot of rights, lot of pointers which restrain government. For example, government cannot do discrimination. Government cannot promote this untouchability. The government has to ensure that there is no exploitation of workers. Government has to ensure that it does not unnecessarily interfere in the religious tradition. So these all are restrained on the government. But directive principles ask governments to do certain things. It enables, it puts a mandate on the government. Now I'll show this with a illustration which is there in NCERT, the brief. So the goal of directive principles is welfare of the people, raising the standard of life. So there are a lot of policies explicitly which are given. For example, government has to prohibit the consumption of alcoholic labor. Government has to prevent slaughter of cow. Government has to ensure uniform civil code. Government has to ensure that there is adequate livelihood and opportunity. Government has to ensure that early childhood care is that. So these directive principles are basically putting certain kind of obligations on the government, that government should do these things, right? While fundamental rights restrain, the government should not do these things, right? This is the first difference. The second difference is these is enforceable by courts, that you can go to court under Article 22 and say to court that government is not providing me these rights, and the court will ensure that you are getting those rights. But you cannot go to court for violation of directive principles. Now, directive principles, because there is a constraint on resource, there is a constraint of resource to provide livelihood to all, there is a constraint of resource to ensure child nutrition to all. Therefore, the government has been given some discrimination, not discrimination, sorry. The government has been given some discretion in directive principles of state policy, that as and when time is there, as and when there are resources, the government will ensure that these directive principles are enforced. Therefore, you do not have to go to court. Court cannot enforce them. There has been changes also. Like in the past, certain directive principles were moved in fundamental rights. Right to elementary education was the one. Now, I want to know from you all, in which part of the fundamental rights, in which article of the fundamental right is right to elementary education there? Which article? It was earlier a part of directive principles, but it was moved to fundamental rights. So tell me which article it is a part of, the right to elementary right education. This will be your homework, right? So, so this is the end of the chapter. As I promised, I'll take some questions. So this is basically the question. So let me choose maybe 2024 and polity, and we have done fundamental rights today. So fundamental rights. This is our portal of SuperKalam, where you can practice all the PYQs, all the prelims PYQs very freely. So you come here and practice these questions from the topic which we discussed. Let me see. Yes. So the question is, writ of prohibition. Just now I discussed. Writ of prohibition is an order issued by Supreme Court and a High Court to a government officer prohibiting him from taking a particular action. Parliament and Legislative Assembly to pass a law. Actually, no. This is not there, obviously, because the court cannot dictate terms to Parliament or Assembly. C is a lower court prohibiting continuation of proceeding in a case, and D is the government prohibiting it from following an unconstitutional policy. So this is not there. It cannot be issued to government officer also. So as I told you in the last few slides, that it is issued to lower courts. So that's why the answer is this. You can get a description also here. Now there is one more question which also we should do. Under which following articles of the Constitution has the Supreme Court of India placed right to privacy? I told you, Supreme Court has extended the meaning of Article 21 and even incorporated privacy into that. So therefore, Article 21 will be its answer. You can go through the description. In the same way, for other topics, for directive principles, for other years also, you can practice it, right? So this will be your the chapter. At the end, I just want to say so reading and understanding the chapter is not enough. You should practice MCQs also. We have made some MCQs for you. Those can be seen on our dashboard on in SuperStart section. Earlier three chapters are also there. If you have not done them, I advise that watch videos, and do the tests. For this particular test also, I will ensure that for this particular class, I'll ensure that there are tests, there are MCQs available here. So I request you all that you attempt the MCQs so that you are very holistically not just learning but also applying your learning, right? So this is it from my end. Thank you, students. You can write to us. If you have any doubts, you can comment here if you have any doubts, and we will meet in next class. Thank you.